For any family in a crisis, the child welfare system can feel like an absolute maze of complicated rules and decisions that can change your life forever. Today, we're going to step inside that maze. We're following one family's very real, ongoing legal battle in North Carolina to try and understand what really happens when the system steps in. I'm not a therapist, I'm a kid. Just let that sink in for a minute. This one sentence, spoken by the 10-year-old girl right at the heart of this case, it just cuts through all the legal jargon, all the complexity. It's a raw, powerful reminder of the incredible emotional weight these situations place on children, and it really captures the high stakes for everyone involved. And this isn't some hypothetical story we're talking about. This is a real court document from Union County, North Carolina. It involves a mother, Kelly O'Neill, and her daughter, Maura. Their story is going to be our guide as we explore the huge challenges that both families and the child welfare system itself are facing. Okay, so before we dive any deeper into this specific case, it's really important to understand the world it's operating in. So let's do a quick rundown of how a child welfare case usually plays out in North Carolina. It all starts with a report to the Department of Social Services, what everyone calls DSS. DSS has to investigate, and fast, within 24 to 72 hours. If they believe there's a risk, they file a petition in court. From there, you have a hearing to determine if neglect or abuse actually happened. If the answer is yes, the case moves on to creating a plan for the family, and then, finally, to long-term planning, which is all about finding a safe, permanent home for the child. So inside that courtroom, you've basically got a whole cast of characters, and each one has a very specific job. You've got DSS, who represents the state. You have the judge, who's the ultimate decision maker. And while the parents have their own lawyers, the child gets their own dedicated advocate too. And that special role is called the guardian ad litem, or GAL. Now, this is a trained volunteer who really acts as the eyes and ears of the court. Their job isn't to be the child's lawyer exactly, but to investigate everything on their own and tell the judge what they think is truly in the child's best interest. And that phrase, best interest of the child, that is the legal bedrock for this entire system. It's the standard the judge has to use for every single decision they make. But what does it actually mean? Well, it's not just about what a parent wants, or even what a child says they want. It's a really complex judgment call about what will serve that child's safety and well-being in the long run. All right, so with that background in mind, let's get back to Maura Bridges' case. It really brings the central conflict of the whole system into sharp focus. That constant tension between a parent's fundamental rights and the state's duty to protect a child from what it sees as risk. You see, from the mother's perspective, the system stepping in wasn't a rescue, it was an all-out attack. In a public video she posted, she described the whole thing as a nightmare built on lies, arguing the case against her was just made up, designed to punish and humiliate her. And that right there perfectly illustrates the core legal tug-of-war. Parents have a constitutional right to raise their own children, but, and this is a huge but, that right is not absolute. When the state believes a child is in danger, its duty to step in can actually override that parental right. That's the tightrope that these courts have to walk every single day. I mean, just look at this. It's like you're reading about two completely different realities. On one side, the court documents lay out a pattern of neglect, missed drug tests, and violating court orders. But on the other side, in her own legal complaint, the mother argues her rights were crushed, that the system discriminated against her because of a disability, illegally cut her off from her child, and even violated her free speech. Now, this document here is central to the mother's entire claim. It's a hospital discharge plan from before the case even started, and it notes a diagnosis of bipolar disorder. Her argument, essentially, is that DSS and the court saw this diagnosis and didn't see a medical condition to be managed. They saw it as a permanent label that meant she was an unfit parent, which she says violates her rights under the Americans with Disabilities Act. The conflicts in this one case don't just happen in a vacuum, you know? They're a reflection of these deep, systemic pressures that are squeezing North Carolina's entire child welfare system. So let's zoom out for a second and look at the bigger picture these decisions are being made in. This system is just grappling with these huge long-term challenges. We're talking not enough money, social workers who are overworked and burning out at high rates, a total patchwork of different rules across 100 different counties, and data systems that don't even talk to each other. All of this creates this high-pressure, chaotic environment where giving consistent personal care is just incredibly difficult. And this data from a state review really shows you the impact on the ground. Look at this.
Over 87% of kids in foster care see their caseworker only once a month or even less. That lack of regular contact is a direct result of the strain on the system. Caseworkers just have too many kids on their plate to spend a lot of time with any single one. So finally, recognizing just how deep these problems run, the state has been forced to act. Right now, North Carolina is in the middle of the biggest effort to reform its child welfare system in a generation. There's a new law, the Fostering Care in NC Act, and it's trying to fix some of these exact problems. It creates state-level rapid response teams, it requires faster mental health assessments, it allows for open adoptions, which can help kids stay in touch with their biological families, and it gives the state more power to oversee all those different county agencies. But even with major reforms like these, that fundamental struggle for balance, well, it's still there. And that brings us right back to the O'Neill case, which is really a living, breathing example of this unresolved tension. As you can see, this case has been on a long and pretty bumpy road. It kicked off back in November 2023. A year later, the court gave custody to the father and ordered the mother to have no contact, but her fight was nowhere near over. She filed an appeal, and that appeal is actively working its way through the higher courts as we speak. So the key takeaway here is that this is far from a done deal. This appeal is forcing the legal system to grapple with some huge fundamental questions. Questions about free speech, about the rights of parents with disabilities, and about that agonizing question of where you draw the line between protecting a child and preserving a family. And that really leaves us with the million-dollar question, doesn't it? How can a system, staffed by human beings, strained by a lack of resources, perfectly balance a parent's constitutional rights with its solemn duty to keep a child safe? There are no easy answers here. It's a question that judges, social workers, and families all across North Carolina have to face every single day.